I have the master switch on, so all of them are live. Everyone has control.
You need to flip that red switch on.
Well, it's 4 o'clock. We have a quorum present. If the clerk is ready, I will call the meeting to order, the meeting of the Ethics Board, and ask the clerk to call the roll.
Already did.
You did. All right, thank you. We appreciate, again, that Wausau residents care enough about the ethics process to come to observe this meeting. And related to that, after the last meeting, a very helpful member of the audience came forward to let us know that there were times at which the members of the audience were unable to hear what was being said. And I'm sure that some of that, a lot of that had to do with speakers facing the person they seemed to be talking to rather than facing directly into these microphones. So I asked the board to be aware of that, be conscious of that, and we'll try and do better this time so that everyone can hear what's being said.
Mr. Chairman, I think for the benefit of those who are present, we should call roll by name so that people know who our ethics board members are.
I think that's a good idea. Would you, Cody, please call the roll?
Dexter,
Here.
Hostler,
Here.
DeVos,
Here.
Mason,
Here.
Kearns.
Here.
Thank you. The first item on the agenda is discussion and possible action concerning the minutes of the February 19th, 2025 meeting. I know that Cody has been extremely busy with elections and handling things that need to get done, and he got the minutes out to us just a couple of hours ago. That being the case, I would entertain a motion to table the approval of the minutes until the next meeting. Is there such a motion?
So moved.
A second?
I'll second.
Any objection? Seeing none, we'll move on to item number 2 on the agenda.
Could you vote on that motion, please?
All right, well, with no objection, let's presume it was unanimous vote. Then, item 2 on the agenda is to review the status of proceedings regarding the ethics complaint against Doug Dinney. Before I go further, I want to thank outside counsel Eric Larson for all the legal assistance he has provided to the board. I'm grateful that we have his counsel. It also seems appropriate to briefly make reference to the public policy statement in the Code of Ethics, which I read from at length at the February meeting, and I'll do so more briefly here. That policy seeks to, quote, improve the quality and integrity of public service and promote, strengthen, and nurture the faith and confidence of the citizens of this community in their public officials and employees. As for the status of proceedings on the complaint, does any board member have any objection to me making a brief review of how we got to this point? Seeing none, at our February 19th meeting, the board reviewed the complaint and determined that it stated facts that, if true, were sufficient to constitute a violation of Chapter 2.03 of the Wausau Municipal Ordinances, known as the Ethics Code. That initial determination led the board to decide to proceed with an investigation. The board has now received responses to its orders for investigation. At this meeting, the board should review those responses and determine whether it has sufficient information to make a determination of probable cause. If the board has sufficient information, it will make preliminary written findings of fact and conclusions based on those findings of whether or not probable cause exists to believe that a violation of the Ethics Code has occurred. If the board determines that probable cause does not exist, the complaint will be dismissed. If the board determines that probable cause does exist, the board may set a date for a hearing affording the respondent with due process rights under Section 2.03.080 of the code, and an opportunity to present his case, and also giving the board an opportunity to exercise further investigative authority under Section 2.03.075. Attorney Larson, did I get all that okay?
Yes.
Thank you.
Yes, that's correct.
Thank you. Is there anyone on the board who wishes to add to that summary of the status of the proceedings?
No, I'm interested in, maybe this is irrelevant, but I'm interested in what a hearing involves. I mean, does it involve just the respondent, or would it involve someone, other people we might find of, say, importance, like the city attorney who appears in this, and the county clerk, the city clerk. Let's do the city clerk, okay? County clerk is enough, and there's two of them. Clerk, of course, anyhow.
We do plan on addressing that later in the
Okay.
agenda,
Okay, if we decide to do a hearing, okay.
if there is such a decision.
Okay, thank
We
you.
will discuss what will occur at the hearing. That's my plan. Next item on the agenda, discussion and possible action on a challenge to the Ethics Board's authority. Before proceeding with the issue of probable cause, it seems to me the board should expressly decide whether it will assert its authority to proceed in light of the respondent's challenge to the board's authority. The respondent has argued that the current member's terms are not staggered properly, which he argues violates Section 2.03.040, Paragraph A of the Ethics Code. Outside counsel has examined this question in a careful 11-page legal opinion. Although I believe the board members have had an opportunity to review that opinion, I ask that Attorney Larson provide the board with a brief summary at this time.
Thank you, Mr. Chairman. I did distribute a paper copy of that opinion. You received it earlier by email. A couple of highlights, I'm not going to go through every point. This seems to work sometimes, but not all the time. So on the question of can these members continue to serve throughout this proceeding, I closely examined that issue, and under Wisconsin law, persons serving in appointive offices shall serve until their respective successors are appointed and qualify unless otherwise provided by ordinance. I looked at the terms for every member who's present here, reached conclusions in that regard. Some of the terms will expire at the end of this month, but if these proceedings continue on after the end of this month, the law states that you continue to have the authority to serve until your successors are appointed. This issue was tested in very publicly, widely followed issue involving a member of the DNR board. And you may remember that issue where a member of the DNR board continued to serve long after his term expired. And he said that state law gives him that authority. And that went to our Wisconsin Supreme Court, and they agreed. Yes, he continued to have that authority until his successor was appointed. And it's not exactly the same law, but it's the same concept. Here, it's a different statute number, but the same idea that you're an appointed officer and you continue to serve until your successor is appointed, even if your term would otherwise expire. The next question, just quickly, there seems to be some possibility that there's a glitch on the appointments when they were made. They possibly should have been staggered terms. And certainly initially it was contemplated that they would be staggered. The first appointments were required to be staggered. While the ordinance doesn't say that successive appointments need to be staggered, that may have been the intent. regardless of whether it is or isn't the intent, you continue to have the authority. You were duly appointed to serve. You were given a term of office. You were appointed by a mayor and approved by, confirmed by the council for that term. So you continue to have that power to serve your incomplete term under the applicable laws. And I described that issue in more detail in my opinion. That's my opinion. If you want to rule differently, of course, it's your decision. But I was asked to provide a legal opinion, and that's my legal opinion.
Thank you, Attorney Larson. At this time, I would move that the board accept the legal opinion of its outside counsel, Attorney Eric Larson, and proceed to exercise authority over the complaint as provided in the Ethics Code. Is there a second?
I would second that motion.
Any discussion?
I have some questions. I think I have one primary question, which would be, would it be in poor taste given other accusations that there were members on the board who maybe shouldn't be the board because of conflict of the interest of the mayor's wondering and his attorney's statement in the letter that we received that questions our legitimacy? Would it be bad to ask the Common Council if they want us to continue functioning in this role? That's the way I think about it, rather than just asserting sort of my own authority or this board's own authority. And these things come to mind. I'm prepared to engage this matter substantively. I've invested an exceptional amount of my free time to look at this. But nevertheless, the last thing I'd want is some public outcry that this is some illegitimate body. And it seems like, in addition to your legal opinion, Attorney Larson, which I certainly value and respect, I'd be curious to hear what the Common Council has to think about it.
I would take exception to that. I think that's only going to delay the proceedings further, pull the Common Council into this. We have a duty as the Ethics Board, I think, to process complaints that have been filed. Sometimes they're politically charged. It makes it difficult. It makes us want to get help from somewhere else, like the Department of Justice or perhaps the Common Council. I don't see any reason why we shouldn't proceed and do our duty under the code and process this complaint. Yes?
I wondered if I can give a little about, I want to talk about the staggered issue, because I might give you some history of it, if you want to understand it. I mean, you think, like Eric, I felt when I first got on this board, there was nobody on it, pretty much. I mean, it was like, well, who are these people? Generally, my experience with committees is that it's very helpful to have people who've been on it to help you. And suddenly we started at ground zero. And then I looked into it, and it looks like I would understand the code the same way that Eric Larson does, in that I think initially the terms were staggered, and then they were made to be 5-year terms, which meant that that would continue. And I think, turns out that was optimistic, because it turned, two things that bother us. One is that our complaints are often few and far between, because there's a very stiff, we might say a stiff code you have to meet in order to make a complaint. You're in danger of perjuring yourself. You can't just make any complaint you feel like, and that's to exclude nuisance complaints. So that tends to have the result that we don't have many complaints. And when I did research, because I was the first acting chair, I did research on the history, and it was at least 7 years since any case had been considered. And by the way, this is irrelevant. They went right into closed session. It's the way they met. But that was it. And it looks like what happened under mayors previous to our previous mayor, And it was even before, I'm trying to think of his name, Robert Milkey. He was the one before the previous mayor. There weren't people on the board. Their terms had expired, and there was no board. And then I think what happened, I don't know exactly why Katie Rosenberg decided to have a board. I mean, maybe there should be one, but shortly, I really know nothing about this, what motivated her, but soon there was a complaint coming up. And having zero board is not the way to face a complaint. So I gathered they did what they thought was best at the time. But to me, it was lacking, I mean, personally, in that I really wanted terms to be staggered. And I thought, given the emergency, they can't be. And what I would propose eventually is that we try to get the council to accept two kinds of things. One kind of change to the code so that it's less likely that the terms will expire. The other one is what to do if it does expire, which I think is a really important thing. We really need that one. Like if it does expire, because there was no thing to do if the terms had expired, how to stagger them again. What was the right way, because the term is just 5 years. So I think this really has a lot of base in that it was, as I said, a very unpleasant experience, but I think it would really help to change the code so that we do have staggered terms. And if they get out of range, if it goes years, like 7 years, without anybody doing anything, there's a way to re-stagger them, but in the ordinance. So, and what I have to say.
That would be for another day, but I do appreciate, I'm sure we all appreciate the historical background that you were able to provide, Doug.
Can I interject a little historical background? Because I was at the last council meeting where they discussed this.
No, this is a meeting of the Ethics Board.
Okay.
Thank you, though.
There's history there,
I'm sure there is, yeah.
yeah.
If I could just comment on what you had said, Brian, I do believe when you look at it, we were appointed and confirmed by the Common Council. So I don't see that it's necessary to go back to the Common Council when we were confirmed with these terms by the Common Council.
Thank you. Any other discussion on the motion?
I do think also that if council were to take issue with any of this, I'm sure that they can take it upon themselves to address that. So if this were an issue that they wish to address, I'm sure that they can actually bring it forward, right? Which, instead of inviting their concern or intention, maybe they can just weigh in on their own.
Sure. Any other discussion?
No, I appreciate
Brian?
I appreciate the conversation and I appreciate the opinion, but I'm also cognizant of the political climate and want to make good on the concerns, if you will. But like I said, I'm prepared to, quote, exert my authority as a ethics board member, and I came here to engage the topic. So I'll proceed with that recommendation and would entertain the challenge if they wanted to down the line.
Thank you. Are we ready to vote on the motion, which is to accept the legal opinion of outside counsel Eric Larson and proceed to exercise authority over the complaint as provided in the Ethics Code? If we are ready, I would ask that all in favor signify by raising your hand. And the vote appears to be unanimous. The next item on the agenda, discussion and possible action on responses to the order implementing the resolution authorizing investigation. I would first note that orders for investigation were signed by the chair, myself, and deputy clerk on February 24th. On that same day, Deputy Clerk Cody Hart accomplished personal delivery to the subjects of the orders with offices in the City Hall, and also delivery by mailing to all those subject to the orders as well as to the complainants. The respondent, the city attorney, and the city clerk all filed responses within the time set by the board. The deputy clerk has indicated that the responses to the orders were promptly provided to the respondent and to the complainants as well as to the board. Any questions or comments from the rest of the board relating to this agenda item? All right, seeing none, we'll move on to item number 5 of the agenda. Discussion and possible action on whether investigation is concluded or what further investigation may be needed. It seems to me that items 5 and 6 of the agenda are so interrelated that we must discuss them together, at least to some extent. Unless there is any objection from the board, I'll explain what I mean by that. I suggest that, well, first of all, item 6 deals with the issue of whether probable cause exists in this case. And I suggest that we can deem the investigation concluded once we have facts sufficient to determine whether there is or is not probable cause. The ordinance states at section 2.03.070 that at the conclusion of the investigation, the board shall make a determination of whether or not probable cause exists to believe that a violation of the ethics code standards has occurred. It also states that if probable cause is found, the board may order a hearing. Providing for a hearing brings with it the authority for the board to engage in further fact-finding. And that's under section 2.03.075. This indicates that an initial investigation can be concluded once the board feels sufficient facts have been collected to make a probable cause determination one way or the other. If the board feels that more information is needed in order to make a determination of probable cause either way, it may continue the investigation before making such a determination. Any member of the board have questions about that or wish to be heard on this point?
Point of clarity, are we talking about specifically the nature of the information that was presented to us? Would this be a good time to bring up a question I have about the information?
We will come to that.
Okay.
This is more, is the investigation concluded? And when can we make such a determination that the investigation is concluded? And what I'm suggesting is that we can do that once we are satisfied we have sufficient information as a result of the investigation to move on to probable cause, the probable cause determination. Other questions? All right.
Wait a minute. I wanna
Yes.
get this clear.
Sure.
That it seems like I'm a little confused.
Put your mic.
Why don't I try that? Okay. I'll repeat that. I'm a little confused in that it looks like the issue of probable cause is, if we have enough information for that, is different from whether or not we are ready to make a decision on the case.
Yeah.
Is that different? Two different things. That is, we would.
Oh, yeah.
Yeah, I mean, like, this is really an issue. Would we like to do more investigation?
Well, right.
Before coming to a conclusion, and, yeah.
What I'm suggesting is that what we need to focus on is, do we have enough to make a determination of whether there is or is not probable cause in order to conclude our investigation? Because the ordinance says at the conclusion of the investigation, then we move on to make that kind of determination. So first, the two are kind of mixed.
Yeah, that's what's confusing.
You mix the results of the investigation with the idea of whether you can conclude it based on whether there's enough there to determine probable cause. So I think there's going to be some discussion of each of those items of the agenda separately, although I think we will need to vote on whether we have enough and whether we can conclude the investigation before we go ahead and make some kind of determination of whether there is or is not probable cause. It is a little confusing.
Yeah.
So what is the consequence of concluding the investigation and just saying we are no longer in search of information? That's just it's a punctuation mark on that portion?
I think you're on the right track there. What it is basically saying, okay, we've got enough to make a determination one way or the other on probable cause. And that doesn't mean that there can be no further investigation or fact-finding, because if probable cause is found and if a hearing is ordered, then we are able to take further evidence, statements, arguments, those kinds of things. We do have further authority to investigate as a result of not only
Through a hearing, yeah.
yeah, I mean, if you have a hearing, that what comes with it is the authority to hear witnesses and do other types of investigating. Are we clear on that now? All right. And then I think the next step is, after trying to get that clear, is to review the advice of our outside legal counsel on the standard for determining probable cause. And I would ask that Attorney Larson read that standard as he has defined it.
Thank you, Mr. Chairman. I have distributed a memo that speaks to that. It's one page. Item 3 of that memo provides a definition of probable cause as follows: a reasonable ground for belief supported by facts and circumstances strong enough in themselves to warrant a prudent person to believe that a violation of the chapter probably has been committed. That's
you.
the definition of probable cause that I propose, and I want to emphasize, as the chairman has, that our only issue today is whether there's probable cause for this matter to continue. We are not deciding the case today. This is still a preliminary, just like it was last time. This today is preliminary. And I should add, if your conclusion is that there is no probable cause, then it will end today. If the conclusion is that there is probable cause, then we will continue. I've, in this memo, laid out code section 2.03.070. It just quotes directly from your ordinance. That's the role we're performing today. I won't read the whole thing, but that's what we're doing today.
Thank you, Attorney Larson. Any member of the board have questions or comments about that standard that's just been read to us? All right. Then next, I think we need to look at whether or not our investigation has found facts or circumstances that warrant a prudent person to believe that a violation of the ethics code standards probably has been committed. With the board's indulgence, I'll review what we have received as the results of our investigation. We have limited responses from the city attorney and the city clerk. They are limited in that they do not provide all the requested records, nor did they provide sworn statements. The reason given is that the Wisconsin Department of Justice advised City Attorney Jacobson that, and I'm quoting here, release of the records while the investigation is still in progress could compromise the ability of the Department of Justice to gain cooperation from potential witnesses and jeopardize their ability to conduct additional or follow-up interviews or obtain accurate and truthful information in those interviews. This could have the unfortunate effect of interfering with the ongoing investigation as well as any potential criminal prosecutions. Close quote. I note that the city attorney's response to our orders does include a copy of her September 26, 2024 formal legal opinion to the city clerk about the clerk's authority to decide whether to use absentee ballot drop boxes for an election. That opinion had been made public prior to the commencement of the criminal investigation. The city clerk's response to our orders does provide information relating to a drop box and its placement, including dates and times. The respondent, in response to our investigative orders, provided a fairly substantial volume of documents, including email, and also providing a 15-paragraph sworn statement. At this time, I'd like to ask the board members for their preliminary thoughts on whether we now have sufficient facts to determine whether or not probable cause exists and the investigation can be included. We might start, I guess, by having a motion to conclude the investigation. If someone wishes to so move, then we can discuss that.
So moved.
Thank you. Is there a second to that motion?
Included.
I would second that motion.
So we have a motion on the floor We'll open that up to discussion to talk about whether we have sufficient facts to determine whether probable cause exists or does not exist, and the investigation can be included. So this is just about whether we have sufficient facts. It's not whether we are finding probable cause. Yes, Doug?
Yes, just a question. Sufficient facts is consistent with wanting more? I mean, that you have sufficient facts for probable cause, but to make a final determination, you want more? Does that make sense?
That certainly,
Right,
it
that's-
doesn't preclude
Right. Is that,
our wanting more facts
Right.
before we make a final
does
decision.
that make sense, Eric? I just,
Well, you need to decide whether there is or is not probable cause. And so there's two sides of this coin.
right.
Do you have sufficient facts to decide which side of the coin you're going to find?
Yeah. On that coin, you're right. Right. See, it might, I mean, I would put myself in the position where I might have sufficient facts to think there's probable cause. And we're basically just reviewing, I think, but I'm not ready yet to make a final determination.
You should not be ready to make a final determination unless the determination is that there's no probable cause. We're not going to find a violation today.
Right, right, okay.
Other discussion, other thoughts?
I'm going
Brian?
to ask the question because just so I can make sure that I have this straight. This would be a good time to entertain a conversation amongst the board about the facts, meaning the information we've been presented. Please correct me. If not, okay.
I
The
think that's
information
correct,
we've been
yes.
presented, to discuss that information, to see if we are ready to move towards the next step, which is moving towards making an ultimate determination. So now would be a good time for me to share my 4-paragraph thing that I wrote specifically about the information we received.
Yes, one quick note. We're not, just to be clear so no one gets confused, we're not talking about making an ultimate determination of whether the code has been violated, but perhaps you're suggesting an ultimate decision on whether we have probable cause. Is that correct? Is
That's
that what you meant?
correct.
Okay.
Yeah. And this is the strangest way I've ever had a conversation in my life, I just have to say. But I welcome the challenge. And if I may, I'll just
right ahead.
comment on what I have. So one is a couple of questions directly to you, Chairman, and then also to outside counsel attorney Larson, which is that I was having some email issues logging in to the city email, and it took me 72 hours to accomplish that, and I ultimately accomplished that by having to physically come here to City Hall and gain access to that. But over the course of figuring out how to regain access to my city email, in which all of this information was given to me, I was told by Deputy Clerk Hart on Monday that the decision was made by the city's outside counsel and the ethics board chair to make the materials that we were asked to read available via email only to us, and to not publish them in a packet to the public, so that the public is empowered with the exact same information that we have. Did I get correct information in that?
I can respond to that. I think you're referring to my letter of March 7th, which actually was provided to anyone who asked for it, including media. The memo of March 24th is my advice to you as the board. You're my client. It's attorney-client privileged until it's disclosed here today. And so that's why it was not disclosed to anyone else prior to today. It's now been distributed, and anybody who wants it can make a public records request, and it will be available. We have not talked about the other documents that I prepared, but I will talk about it now. You're required to make your findings on probable cause, whether it's for or against, in writing. And in anticipation of that, I prepared findings that would find probable cause and findings that would not find probable cause. And rather than present that to you only here today, I again presented it to you, to the board members, attorney-client privilege information to only the board members, so that you would have a chance to review those before we came. And the idea is not that you pick one or the other necessarily, it's that you have a framework for reducing your decision, whichever it may be, to writing. And I'm prepared to make whatever changes you may want to make to those documents. Again, they now have been discussed publicly. They're no longer draft documents in the sense that our laws specify, and people can make a records request for them. Does that respond to your question?
It responds to half of it. The other half of the question is also we were presented, so when I was able to gain access into my city, county email address, what I discovered is that between March 4 and March 25, there were 14 separate emails sent to me, which I couldn't gain access to despite my repeated efforts, that contained more than 40 attachments, ranging in page length from 1 to, I think, 11. And also, some of those documents, to the best of my ability, appeared to be duplicates, which leads me to say this, that there really is no contents or nor index of all of the information that was sent. So in effect, what I'm saying is, I don't know that I actually received all of the information because no one gave me a document saying, these are the documents you should expect that you should come prepared to have read. I have no idea if I have all of them because it's just, like I said, 14 separate emails sent over 21 days with 40 attachments ranging in page from 1 to 11. And specifically to that level of frustration is I sort of ask, again, maybe rhetorically, is why weren't those bits of information released to the public? I understand the attorney-client privilege element of this, and I respect that decision. But what I don't understand is why the public doesn't have the exact same information that we're looking at. And ultimately, I don't understand why I'm confused about whether or not I have everything that the clerk intended to send.
Well, the documents that you're talking about were the submissions that we received from counsel for the respondent, and they're both Attorney Larson and I separately tracked what was being sent. It was all, each of the documents was sent under a cover letter from the respondent's counsel, and it identified, and the final letter identified how many documents we should have under how many email letters that we received. And it was pretty clear to both of us that we were missing some. So there was some further discussion with the clerk to have him double check and make sure that everything was out. So it was confusing, it was difficult. As to the second part of your question or your point, and that is, why wasn't it released to the public? Well, the board hasn't decided to release it to the public. If we decide to do that, or if, I mean, I think it is going to be part of whatever gets released to the public after this meeting. But that's why. I mean, with the advice of legal counsel, that we don't release confidential information. I would agree with that, especially to the extent that the confidential information there is an agreement among the board that it be released. So I think it's premature to expect that it would have been released.
Yeah, if I could respond, I'm not aware of a records request having been made. If there was a records request made, wasn't brought to my attention. We are sitting here as judges, And if you imagine a court receiving filings for the court, they're the court's record. These are your record, and they're provided for your review. This is not an issue that's going to be decided by public opinion. It's going to be decided by this body. And this body is conducting an investigation, asked for documents to be submitted, and they were submitted. They're in the record. They're not being hidden.
So if I may ask a question, like in the event that we were to pursue further discourse on these, would it be possible to get a more indexed version of what we've received to make sure that we're all on the same page? Like, not asking for them to be numbered and paged, but I think that might be part of your point too, that it's been kind of not only confusing as to what is in the documentation, but also that we all have the same documentation, and that your question about the public having access to it isn't really part of this equation, but us having an understanding that we all have the shared information, to me, actually was something that I considered as well.
Yeah, I think I appreciate the perspective that eventually all this will be released to the public. That's good. I can understand why it's being kept private now, so I appreciate
I have
that.
to stop you. You're not saying that correctly. It's not that it's being kept from the public. It's being held by this body, and to my knowledge, it hasn't been asked for by the public.
Fair. So I'll offer no qualification. I'll just move back to the other half of it, which is that I specifically asked the deputy clerk, I said, well, can I come by and pick up a packet? And the answer was no. Look at your email. And that's what I found was
So I'd be happy to assist the board, because I think we all got a slew of emails, and it was very confusing. I had my staff organize it. I refer to the documents in these draft decisions that I prepared by exhibit numbers. I've prepared them in the forms of exhibits. I can forward that on to you if you think that'd be helpful.
I know it would be helpful.
Yeah, I would really appreciate that.
I know it would be,
I attempted to do what your staff was able to do at home with a pen, marking out pages, but it would be highly beneficial if we could have each document kind of laid out as its own exhibit.
and actually, I would point out that I prepared a chart on my own at home, so it's possible to do this. It takes a lot of time, and if you're not retired like I am, you may not have that time. So, and I agree with Brian and with everybody that it would be very useful for us to have that kind of information.
Want to make a?
Yes,
Want to
go
ask Brian one question. If the longest document you saw was 11 pages, then you must be missing something, because one of the documents I have goes to 22. So you might well be missing something.
Well, there may be, you may be talking about the respondent's response to the complaint,
Right.
because that had that, what was it, 8-page letter in it, in addition to the response itself.
Yeah, in addition to
was quite a bit.
brief that went to a defense, I mean, a request for, I think, the private property of.
Yeah, right.
The request, and why the search warrant must be returned. Anyhow, that was 22 pages. You didn't run into anything like that? Is that not?
Perhaps I did. I mean, I engaged the material to the absolute best of my ability, but furthermore, in terms of investigating the material, just sort of, also, I just want to state some elements of information that I've done quite a bit of work that I've been able to do in the last 36 hours or so researching it. Furthermore, there's a lot of emails shared with a lot of just names of people. For instance, in one email exchange between Mayor Denny, we're referencing someone named Leo, and then Leo references Eric, and then Eric CC's Matt Barnes. I don't know who Leo is. I don't know who Eric is. I know who Matt Barnes is. I know who Mayor Denny is. And so I'm trying to illustrate what I hope to get is that something that details, this is what you're seeing, an email exchange between the mayor and whoever Leo is and whoever Eric is, because I think that matters to know Because it certainly seems to matter in, as we engage this, to
Yeah.
establish intent and so on. It certainly matters to my ability to be able to investigate this and render an opinion about it and with my integrity intact.
Okay.
Thank you, and I think it certainly can matter. It doesn't mean that there aren't items produced in the response that wouldn't necessarily be relevant to a determination. I think that we asked the respondent and the other subjects of the investigation to provide any documents that they have relating to, that discuss drop boxes at all in any sense. And the mayor complied with that request and gave us everything he had, I assume.
Yeah,
And so there's a lot of information there, and not all of it necessarily is necessarily relevant or material to whether there's probable cause or whether there has been a violation. But I can understand your frustration, and the computer difficulties you were experiencing really made it terribly difficult for you. I actually had a ransomware attack that shut down my computer for about a week during this time period as well, so.
I mean, I could say personally that it was a lot of work.
It was, yes.
I mean, going through and trying to separate which response came from whom and all that stuff. It was a lot of work. I decided to print it all out. And then I found Eric's exhibit idea very helpful.
I think that would be very helpful, yes.
Yeah. So if you don't have that information, then you may feel you can't act on it.
yeah. I have 3 pages of questions, but I feel like I should let the chair reorient this meeting before I continue to entertain the questions.
I guess I also have 3 pages of questions about the material that I consumed.
Right.
Is that something that we're doing today? Like, my question is the purpose of this meeting to establish that we are going to or not going to further discuss this? And then if we were to decide to pursue that discussion at the next meeting, then would we, if we had questions, would we be addressing those questions from each committee member as we discuss this further?
Well, if I understand your question, we need to keep in mind, I think, that we're only talking about whether there's enough to determine probable cause. We don't need to parse through all of the results of the investigation, all of the documents and all of the information, and get all our questions answered on all of that. Well, all we need to do is say to ourselves, is there enough here for us to make a decision on probable cause? And, I mean, maybe it would be helpful if I give you my thoughts on that, and then, you see what you think of that. I believe we do have sufficient information to conclude the investigation and determine probable cause. And I will cite some things from the investigation that we have that I think support my conclusion. First of all, the respondent's sworn statement at paragraph 4 acknowledges that on Thursday, September 19th, 2024, the city clerk informed him of her plan to deploy an absentee ballot drop box, and that she'd been advised by the city attorney that she had sole discretion in the matter. Then the city clerk's response to our order reflects that a box, locked and empty, intended to be used as a ballot drop box, was placed in front of City Hall on that same day, Thursday, September 19th. That can be found in the city clerk's response. While clearly aware of the clerk's plan, the respondent interfered with that plan on Sunday, September 22nd, by confiscating the locked, empty box and holding it in the mayor's office until September 29th, 2024. This is reflected in the respondent's sworn statement at paragraph 7 as to confiscation, and in the respondent's email to the clerk on September 29, 2024, as to the return of the box. The city attorney's legal opinion, number 24-5, addressed to the city clerk, and dated September 26, 2024, stated that, quote, pursuant to Wisconsin statute section 7.15 sub 1, it is within the statutory authority of the municipal clerk, not the mayor, to utilize secure drop boxes. The city attorney stated in her opinion that it affirmed, quote, the consistent advice I have previously provided to both you and the mayor. So based on those select facts, I think there is sufficient information here to conclude the investigation and also to reach the conclusion that the facts and circumstances are strong enough in themselves to warrant a prudent person to believe that a violation of the Ethics Code Section 2.03.030, paragraph J, probably was committed when the respondent, acting in his official capacity as mayor, knowingly acted in excess of his lawful authority by interfering with the clerk's plan to deploy an absentee ballot drop box. That's how I approached it. I don't know if others, if that helps any of the rest of you in deciding whether we can conclude the investigation. Further comments?
I don't disagree with anything that you just laid out. So I guess how granular we get with the evidence that we've been given, I think, is the question that maybe is on my mind at this point. Like, are we drilling down too far? Do we need to just answer this question at the very top, which I think you very succinctly did? So if that is the question, and that is a response that I agree with, I think then we are in agreement that this would then be cause.
Right. But it's at a certain level. I like your idea of, at a certain level, is this probable cause? And as far as I can see, I'd probably say yes. But it's not, it's looking at all of the material and looking at what this objection said, what that objection said, and trying to get a clearer idea of what the pattern was. And given that, I'd probably say, yeah, that's enough to indicate probable cause,
Right.
to go that far.
I think we can get bogged down on all of the facts and all the documents,
Right.
all the information we have,
Got a lot.
and debating whether we believe each and everything in that long list that we're going to get from Attorney Larson of the investigation results.
Mm-hmm.
But what we really need to do, I think, is there enough? Can you find enough in there
Mm-hmm.
without getting bogged down in all the facts? Is there enough in there? And to me,
To decide.
I think there is. Robin, any thoughts?
No, I guess I am on the same page. I think, to put it succinctly, and these are the fact that it was, there was an intent to place it, and then there was a removal of it, and then some other the subsequent items that came out. I would agree with you as to a probable cause. I don't know if we have a motion on the floor right at the moment.
I think that's a
We-
good observation.
Oh, the motion on the floor is still whether we have concluded our investigation. That is the motion that's on the floor that was seconded.
We've concluded our,
Whether we have made a conclusion of our initial investigation for this probable cause stage.
yeah, okay.
That's the motion
But
on
we're
the
not
floor.
totally done, right? That's all I care, that it doesn't say we're completely done.
Correct, yes.
Okay, thank you.
Brian, do you have other thoughts?
I'm prepared to vote on it, and I'll abstain, is what I'll do.
Okay.
Just,
Understandable.
Sure.
I am following the conversation. I certainly think that I'm more than equipped to continue engaging the conversation. It sounds like I know which way the vote is leaning, just listening to the conversation. But I can't in good faith say that it's concluded on my part.
Thank you.
Thank you. Yeah.
All right.
All right.
Any further discussion? If not, let's call the motion to a vote. And that motion is that we have sufficient information to conclude the investigation. All those in favor signify by raising your hand. Opposed? Abstain?
Abstain.
We have 4 in favor and 1 abstention. All right. With the investigation concluded, We now turn to discussion and possible action concerning preparing and adopting preliminary written findings of fact and conclusions of law concerning whether or not probable cause exists to believe a violation of Chapter 2.03 of the Wausau Municipal Ordinances has occurred. So this is basically the decision on probable cause. And as Attorney Larson has noted, he's provided us with detailed drafts of two alternative findings of fact, conclusions of law, and determinations, one which determines that probable cause does not exist, and another that finds that it does exist. They are both based on all of the facts produced by our investigative orders and do not specify particular facts on which the board might rely. That does not preclude the board from adding specifics to the findings of fact and conclusions. The chair would entertain a motion to adopt one of Attorney Larson's drafts of the findings of fact, conclusions of law, and determination. So he provided us with the two drafts. One is that there is probable cause, one is that there is not probable cause.
I'm sorry, I'm confused. Didn't we just vote on that?
No, that was a vote on whether to conclude the investigation,
Oh,
because the ordinance says, once the investigation is concluded,
Yeah.
then you vote on probable cause.
so I voted to conclude the investigation? Oh, my gosh.
Did you not want to?
No, I didn't want
Oh.
to stop, I mean, conclude the investigation.
But if you recall, we could still continue investigation at our finding of fact hearing stage.
hearing.
Yes,
Okay,
at a
that
hearing
sounds-
stage.
sounds a little sneaky to me,
It's a
but-
preliminary investigation.
Right, okay.
Yes.
Okay,
So it's
conclude.
just whether we felt like we have enough investigative information at this
To make-
point
to make
to make a
this-
probable cause
Yeah,
determination.
that's.
Thank you,
okay.
Robin.
Thank you. You rescued me.
We're trying to follow the
Right.
detailed steps
I know,
laid out in
I
the
know.
ordinance in some kind of order here.
Right.
So now I'm asking, is there a motion to adopt one of Attorney Larson's drafts?
Okay, let's see.
Either that there is probable cause or that there isn't probable.
Right, yeah, well,
Yeah, I would move to adopt the draft that there is probable cause
Yeah.
of a violation.
We have a motion, is there a second?
I'll second it.
It's been seconded. Discussion.
I feel we've sort of already done
We've
some
pretty
of that.
much-
We've
yeah,
done
that's
that
why it said-
discussion.
Right,
There's such an interrelation between those two
Yeah.
stages that
Yeah.
you get a lot of the discussion kind of up front. So I'll take that as calling for a vote on the motion. All those in favor, please signify by raising your hand. Opposed? Abstaining? Again, we have 4 in favor and 1 abstention. And finally, on this topic, I would also entertain a motion that the findings of fact, conclusions of law, and determination should be finalized and served by the deputy clerk by mail on the respondent and also all of the complainants. The code does not require service on the complainants, but I think that should be done. Is there such a motion?
Can you clarify what you just said?
Sure. This is basically just to approve that a copy of the findings and conclusions and determination that we just voted on, the copies get sent to the complainants as well as the respondent.
So, sorry, just a question.
Yeah.
Obviously, we're not talking about sending this precise document. We still are leaving room to make alterations if we decide so. But this moment, we're saying, when this is complete, it will be sent to these individuals.
I think we just voted on probable cause.
Sure, yeah.
Are you anticipating that should be amended?
No, I'm
Oh,
just
okay.
asking the question. So the document that we agreed on, that is a draft, or our agreement in the last vote was to then take that document as is and then send that to these complainants and respondents, right?
Right. It would need to be finalized by Attorney Larson.
Right, so
And by that, I mean, take the draft watermark off. You didn't direct any other changes to be made, so I'm
Right.
not intending to make any other changes at this time, but if your question is, can we make changes, then we can reconsider the last issue. That'd be a motion to reconsider that, to make changes to it.
I think just the dates, there's a couple blanks for dates that need to be put
Yeah,
I
in.
guess I would
Okay.
just rather spend a little more time with the document before, if that is the case. I thought, honestly, we were saying that we were choosing one or the other, in the sense that we've already made the declaration. So I guess if it's an as-is vote, I would rather spend more time with it than I just had.
All right.
And maybe have a chance to, just before I put my stamp on it, be able to kind of take it in a little bit more than I was able to today.
Okay. So are you, when you say spend more time with it, you asking for further discussion? You have further comments you want to make about it?
I guess, in my opinion, I would like to be more familiar with it in order to make comment on it.
Uh-huh.
So, and maybe I'm the only, I only received one of these, and I read it thoroughly, and it happened to not be this one. And I just want to make sure that both documents were essentially identical, sans the last portion that calls out whether there is or is not probable cause. And you can confirm that for me if you'd like.
The two versions are essentially identical. All that they do is they incorporate, they describe the requests that were made in your investigation. They describe that a response was received and the response is attached as an exhibit. It incorporates all of that information, and then it makes a finding ultimately of whether there is or is not probable cause.
Well, and yeah, if the document essentially is, if they're both identical, I have read this cover to cover. I just had the version that I personally, we didn't vote on just now. So when we voted to accept, I didn't have a copy of that. So I just wanted to be very clear that the last 5 paragraphs then are
Yeah.
new to me, so.
I would ask that you discuss with Cody Hart the problem that you did not get both copies.
I don't have a copy.
You don't
I
have
sent them out,
They-
they went together. Both versions went in the same email.
I got them both at
They're
the
in
same
email,
time,
yeah.
same email.
I printed them and only one printed, but that could just be an error of printing.
Sorry to hear that.
To revisit this, so my comfort with this is more clear now than it was before, based on the fact that the documents are essentially the same sans the last portion.
Yeah,
I just was not prepared to suddenly accept a document that I had not read.
understandable, yes. I'm glad you brought it up. All right, so we now move on to discussion and possible action on the next steps, now that the board has made a determination of probable cause. Section 2.03.070, paragraph A of the Ethics Code provides that our preliminary findings of fact and conclusions may contain an order for a hearing to make a final determination of whether a violation of the Ethics Code has occurred. It provides that the board shall serve any order for hearing on the respondent, and if a hearing is ordered, it is to commence within 30 days after the date it is ordered, unless the respondent petitions for and the board consents to a later date. First, I would entertain a motion on whether or not the board will order a hearing. So not scheduling at this point, just the simple question of whether we're going to have a hearing.
But isn't that in this? Sets a hearing for, ordered that.
Well, yeah, that'll be filled in on that, once we
Right.
make a decision. We haven't voted on, I see what you're saying, it's on the draft, so
Yeah. So if that was, I
So,
thought
is there-
that was it, yeah. You mean
if
we
the
have
rest of the board sees it that way, that we've already approved of having a hearing because it's in the draft, then we can move on to the next topic. Any objection to doing that? Attorney Larson?
Well, it does say that there's going to be a hearing. It doesn't say when.
Right.
There's a blank as to when.
So now,
Right.
that's what we would move on to next. And that is, as noted, we hold a hearing within 30 days after the date of the order, which is today, unless the respondent petitions for and the board consents to a later date. Since we have the respondent here with counsel today, I'm going to ask if the respondent would petition wants to petition for a date later than 30 days beyond today's date. Could you answer that, please?
Yes, I'm Andrew Irwinson from Early Burish in Madison. We would absolutely petition for sufficient time so that the city attorney and the city clerk can make full and complete responses to the investigative demand. The fact that this investigation was closed while the city attorney and the city clerk were invoking some sort of privilege.
Can I ask that you step up to the mic to get that?
Yeah.
The question is whether you want time, so maybe you could,
That's the
Yeah,
mic
the
over there.
question is whether the respondent needs an extension of the time from 30 days to some later date in order to prepare for the hearing.
Yes.
Not whether what's going on with the city attorney.
Well, the respondent requests no less than 30 days following a complete response by both the city clerk and the city attorney to this board's investigative demand. We have fully complied. This body, as is its prerogative, has elected to go forward and make a probable cause determination and close its investigation without that response. We would object to any hearing unless and until both the city attorney and the city clerk
Well-
complete their investigative responses.
You can object all you want. The fact of the matter is, we don't know when the investigation is going to be closed by the Department of Justice. We have no idea. I mean, you're asking for an open-ended shutdown.
I'm asking for justice and due process.
Well, we're talking about the hearing date, which has got to be within 30 days of today's date, unless you petition, and I'll take that as a petition for a later date, but you have not specified what later date.
It's 30 days after the city attorney and the city clerk make complete responses to the investigative demand issued by this board.
the investigative demand of this board was resolved by the board determining that its investigation is complete.
There was not a response, a complete
That's
response
correct.
by either the
That-
city attorney or the city clerk.
That's correct.
The petition is that Mayor Denny not be required to submit to a hearing on this issue unless and until the city attorney and city clerk make a complete response. That's the petition. If you want to reject it, reject it.
Your petition has been noted, but it does not assist us in setting a date for the hearing. So, that being the case,
The respondent finds himself in the same unfortunate and uncomfortable position.
finds himself in the same uncomfortable, well, I'm sorry for the respondent that he's uncomfortable. The fact of the matter is, our job now is to set a hearing date. You have not been helpful in us to set a hearing date. So we can either do it within 30 days, or we can grant some additional time that the board may choose. So,
Has the board sought an opinion from legal counsel as to the credibility and legitimacy of the invocation of attorney-client privilege as it relates to the DOJ investigation?
sir, I think you are now out of order, and I would ask you to return to your seat.
I believe that before the board rules on this petition, that question ought to be answered for the record, because I think legal counsel's opinion and thoughts on the subject could assist this board in meting out what constitutes due process under the Wausau City ordinances.
All right, I will ask our legal counsel to address that at this time, and I will ask you to return to your seat. Please.
I'd like to remain seated until the petition
No,
has been
because
ruled upon.
this is not going to be an argument between opposing legal counsel or the board's legal counsel and the respondent's legal counsel. You have made a request that we seek the opinion at this time of our legal counsel. That's the end of it as far as you're concerned. I simply wanted to give you the opportunity to ask for a set period of additional time after 30 days if you wanted to. You're trying to turn that into giving you the opportunity to make arguments and to make objections. This is a meeting of the board. I was simply inquiring whether you wanted additional, a set period of time for the hearing. It's a simple question.
That's
You're
correct.
turning it into something else.
There's a petition pending. It's not been ruled upon. I would prefer to remain seated where I am until there's a vote.
Mr. Chairman,
Yes.
on the board in an earlier action tonight determined that its conclusion, it had the information it needed to make a determination on probable cause. In doing that, the board necessarily decided that it had whatever it needed from the city clerk, it had whatever it needed from the city attorney. Because you concluded that you do not need more information in order to make a determination. So yes, we do not have everything that you asked for from the city attorney or from the city clerk, but you had enough to make your conclusion. So I don't think there's any loose end there. You've made your determination. But on the question of should we delay this proceeding until the state has acted, that really is their request, is another way of phrasing, as I understand it, their request. They want to wait till the city, until the state has concluded what they're going to do, and then and once that's decided, then they want an additional 30 days. That's certainly within your power. We could delay this proceeding, and so that I would ask you to consider it in that context. Do you want to delay our proceeding until we know what the state is going to do?
Thank you, I appreciate that, and the board can address that. But again, I asked counsel to return to his seat. This is a meeting of the board. This is not a hearing where counsel make arguments, and we will take up that subject of whether the board prefers to delay pending the investigation by the Department of Justice.
Mr. Chairman, and I'm not attempting to be argumentative in any way. This is my opportunity to make a record for my client in this proceeding. And I
This is not
urge
an
you
opportunity
to
for you to
respect
make a record for your client. This is a meeting of the board. We are making decisions. We're not here to hear arguments from counsel, and that's what you're attempting to do.
I'm
You're
not
trying to
arguing.
hijack the meeting.
I'm merely making a petition, and I want to make a record so that if and when a court reviews this proceeding, the court can make a determination on a complete record. Now, based on Mr. Larson's comments, I have another concern that I want to add as a point in support of the petition. If
You're
what I'm
making
hearing-
arguments.
No, I'm not.
Yes, you,
I am stating the basis for the petition that I've made. If what I'm hearing is that this board, in ordering a hearing to proceed, is not going to conduct any further investigation, and it's going to go to a hearing based strictly on what's been submitted to this point, then I would like to have that made clear, because I would object to that.
you object to what?
If the board were to close its investigation for purposes of this probable cause hearing and do no further investigation and require my client to submit to a hearing on the merits in 30 days, that is further support for the petition we've made. That would be a highly objectionable procedure.
That sounds like an argument.
It's the basis for the petition.
Well, are you ready to return to your seat?
Is that what you're demanding?
I'm demanding that you return to your seat and allow the board to continue its meeting.
I will respect the chair's demand.
Thank you. All right. As our outside counsel has indicated, this might be a good time for us to take up the question of whether we should delay any further action until the Department of Justice's criminal investigation is concluded. Members like to be heard on that.
So at the outset of this conversation, we had discussed kind of how there is no overlap between the DOJ's case and what we're discussing here, right? Like, we are a board of deliberating on the ethics of our city. The DOJ's investigation, as we made clear, I think, in our first meeting, should not have a relevant role in what we're doing here. And I understand there's an overlap with the evidence that we are being, I guess, that is being stalled or being caused to not be provided to us based on the attorney and the city clerk. But again, I go back to the idea that that case has very little to do with us other than the slight interruption of the producing evidence. So I would say that aligning ourselves with a timeline with the DOJ brings us back to something we very much tried to avoid at the beginning of this deliberation.
I agree. Doug?
Yeah, one thing the attorney for the mayor said was that we are not doing any further investigation ourselves. And I thought that's not what I was voting for. I thought in addition to a hearing, and we haven't determined who's going to appear at the hearing.
Right.
Because we could indeed ask for the city clerk and for the city attorney to appear at the hearing.
Absolutely.
So they can correct each other or do whatever. I mean, they can be here, but waiting, it's true, waiting for the, DOJ to decide it, I give up on.
Yeah.
I'm not, it's not a thing I can do, and we do try to separate ourselves from that issue. I mean, I was hoping for it in a way because I thought it might add clarity. In fact, I was interested in the suit or the complaint that of Douglas and your wife's Jean Denny, your property, having that back. And I wanted to find out if that had been concluded. So I went to the court, which is the best place to go, and I found so far it's not been concluded.
I see.
But so I want to be able to do that kind of thing as well, do other determinations besides the hearing.
Brian?
I found the exchange interesting. And then listening to Doug's comments about having the investigation, or the hearing, excuse me, invite the city attorney and the city clerk to be present to answer questions, which invited a secondary question to me, which unfortunately I can no longer ask to Mayor Denny's counsel. As my understanding, he's returned to the galley. But nevertheless, if he can answer the question is, would Mayor Denny's counsel be amenable to a hearing pending the affirmative presence of the city attorney and the city clerk to answer questions, or is his opinion that it should be all available in writing in the full document? I don't know if he can answer the question. I defer to the chair.
Well, I'm not even sure what the question you have for him is. Could you restate it, please?
Happy to. So I'm wondering if because we don't know if the city attorney or the city clerk would make themselves available to the hearing, right?
We can subpoena them.
Right.
And I would recommend we do that.
Right.
Okay, so if we if we vote to subpoena them, would that satisfy the mayor's attorney's wish, because they would be present?
Well, based on what we've already heard, it would not satisfy them because they wouldn't have fully complied with the original investigative order. So I don't think there's a need to get his reaction on that. I would like to make a couple of comments on this. I oppose the delay of these ethics board proceedings on the complaint in the hope that Wisconsin Department of Justice will do our job for us or make our task easier. Wisconsin Department of Justice investigators are not investigating whether Standard J of the Wausau Ethics Code was violated. They are presumably investigating whether specific state and/or federal election laws were violated. And we have no idea when that investigation will be completed. And after it's completed, there's no guarantee that the results will help us do our duty. If it decides not to prosecute, that does not mean that the respondent did not exceed his authority in this matter and therefore violate the ethics code. If the department decides to prosecute, it's likely that that may take many months or even more to reach a decision in court. The restrictions on witnesses may have to continue during that prosecution. So I don't know that that's going to be an answer for us. The ethics process is different from the criminal process in many important respects. It doesn't apply to everyone in general like the criminal law does. The ethics code only applies to Wausau public officials and employees. The policies that the ethics code seeks to further are different from the policies behind the criminal laws, although there certainly is overlap. The criminal code is generally designed to promote public safety and social order. The policy behind the ethics code is designed to improve public service and promote, strengthen, and nurture the faith and confidence of the citizens of Wausau in their public officials and employees. Punishments and sanctions also differ. Criminal conviction can result in imprisonment. The Ethics Board finding that a Wausau official or employee violated the ethics code does not result in prison. Failing to use the ethics process because a criminal investigation is pending may be easier than enforcing the ethics code, but it undermines the purpose of having such a code. Why have an ethics code standard that prohibits bribery, for example, if there are also criminal laws that prohibit bribery? Because we want to promote, strengthen, and nurture the faith and confidence of the citizens of Wausau in their public officials and employees. Even if bribery is criminal behavior, it still is also unethical behavior. And we should say so. Failure to use the ethics code when we have reason to believe a violation has occurred is stepping away from ethics, and that may encourage future unethical conduct by Wausau city officials and employees. Robin, did you have any thoughts on this matter?
I have no further thoughts than what you've just stated.
Do we have a motion to delay or postpone the hearing based on the criminal investigation? Seeing none, I think it falls to us to set a date for a hearing in this matter then. And I think we should probably be looking at availability. At the just short of the 30-day deadline that we're dealing with. We need to determine, so 30 days from now, if we could look at our calendars just before that, maybe in the week before that. Does anybody know that they're not going to be available during that time period?
What week are we looking at?
Well, today is the 3rd, so we're looking at the week, basically a week before the 3rd of May.
Do we know this room's availability?
Yeah, I was just going to request if you could pause for me to check the city calendar.
Yes, thank you, that would be appreciated.
Third is a Saturday, isn't it?
I don't even know.
So this would be the, the week of May 5th then, because the 5th is a Monday.
Fifth is a
Okay.
Monday, yeah.
Well, it'd be the week before that if you want to be before 30 days, so it'd be the week of the 28th.
Yeah, the ordinance requires within 30 days, so.
So the 1st is a Thursday then.
First is Thursday. Second.
Just as a starting point, for me, it looks like everything on my calendar that week I could move around, except I have a court hearing on the April 28th in the morning, so I could not do April 28th in the morning.
Anyone else?
The 28th would be difficult for me in the morning as well.
Okay. Probably be preferable if we could have a late afternoon meeting again in this room. I know Cody is checking on the availability of this room.
So you're looking at April 28th?
Well, anytime during that week, I guess. But I know Tuesdays are, well, the second Tuesday and the fourth Tuesday are common council meetings.
The 29th is a fifth Tuesday.
Pardon me?
The 29th is a fifth Tuesday, so I don't know that we'd have those conflicts.
We don't seem, yeah, it doesn't seem like that's a problem.
Right. Yeah, that's right, it's a fifth.
However, the council chambers is being renovated, so we've moved the council date to the 29th
Oh.
right now. Because for the week of the 14th to the 25th, the council chambers will not be available. So the council date for that second meeting of the month was moved to the 29th.
So the 29th doesn't work.
So the 30th?
The first would be difficult for me. The 30th does work.
30th would work for you?
Yeah.
Thank you. How does that look, Cody?
Good so far. I need to check one more calendar.
Sure.
30th. April 30th, interesting, okay.
Would you require closed session at all?
We might.
Because there is a meeting in the courtroom, which is right alongside of here. So the chamber is available, but Mapleton might not be available. It doesn't mean we don't, we can have closed session in a different place, but a more convenient closed session is,
Well, I think we can solve that problem.
yeah.
I mean, a lot of times my clients will make everybody else leave, please.
Yeah. Okay, then the 30th works for the council chambers.
All right, if no one else has an objection, let's go with the 30th. Should we say 4 o'clock again, as we had with this meeting?
Okay.
That works for me.
30th of April, right? Okay.
Now, I have one more thing that I think we should address, and that's the question of witnesses. We should address that now so we can avoid the need for an additional interim meeting to
Right.
make a decision on that.
That would be helpful.
Now, certainly, the respondent is expected to be there. The complainants are certainly invited to be there, but I think we should issue subpoenas, which we have the authority to do under the code, to the city clerk and the city attorney. Who knows? It's even theoretically possible, at least, that the criminal investigation will be over with. But regardless, I would like to see them at the meeting and find out what they are able to tell us. And certainly, the respondents' counsel will have an opportunity to question them as well. So, I guess I would move that we subpoena the city clerk and the city attorney to attend that hearing and be prepared to answer questions.
Do you want to make it at all one motion that we're,
Oh, the date and the subpoena?
well, yeah, but I mean, that we want the respondent and them at the same meeting? Oh, sorry, thank you. Okay, sorry. I was just wanting to put it all in one motion.
But
No, one motion would be that we ask for a hearing, and the hearing be scheduled, and that the following people are expected to be there.
we'll take that as a motion that we will have a hearing at 4 PM on the 30th of April, and that the respondent is invited to attend. We expect he will attend. The complainants are invited to attend. The city clerk will be subpoenaed to attend, and the city attorney will be subpoenaed to attend. Does that
Right.
provide what you need? Is there a second to that motion?
I'll second.
It's been moved and seconded. Any discussion? Just point out that it's my understanding Attorney Larson will finalize the documents we're talking about, the findings and conclusions, and the draft of the order, as well as the subpoenas, and that the deputy clerk will serve those documents. So that's our understanding, unless we're corrected.
They'll be signed by the chair.
It'll be signed by the chair, yes.
Yes.
If there's no further discussion, I'll call for a vote on that motion. All in favor signify by raising your hand. All opposed? Appears it's unanimous. All right.
I'm just wondering if we would want to, if there's any need to set another meeting in a couple weeks after we've had a chance to get everything in order. I was just thinking about Brian's concerns, whether there'd be anybody else contained in those packets that we would want to subpoena. The other alternative is at that hearing, we can, I assume, always adjourn that hearing if we want to continue that hearing to another date, depending on who we've called as witnesses at the next hearing. So just a couple different ideas as to making sure that, if there's anybody else, that we have sufficient time to be able to know who we're going to call.
Yeah, that's a good idea. I think it is important for us all to have an opportunity to review, to go through all of the documents and statements that we have, and it really doesn't sound like Brian's had an opportunity to do that. So it sounds to me like a good idea that we have a meeting for the specific purpose of addressing what was produced in the investigation, whether we have questions on it, for that limited purpose.
Just for the limited purposes of knowing what else we would need at the
Right.
hearing.
And the possibility that we might act on that, everybody being able to digest that information, and there may be a request or a motion that someone else
Correct,
be subpoenaed to attend the hearing.
yeah.
Is there, you want to put that in the form of a motion?
Sure, I guess I was just asking for another hearing, another date that we could meet.
Okay, well,
So
let's
I
see if
could
we can
move
come up
to-
with a date. Yeah, let's see if we can come up with a date.
And I was just thinking in about two weeks or, sometime in the middle here.
I will also remind the board that the council chamber will not be available from April 14th to April 25th.
How quickly do you think your office could get us all of those documents, Attorney Larson?
I sent them as we were sitting here.
Okay.
If you didn't get them, let me know, but you should have them in your inbox.
I guess I'm just looking at, would even 1 week be available, be appropriate? to
That would
give you
work for me.
time? So if we could look at maybe next week, April 10th, at the same time, 4 o'clock?
I can't make the 10th at that, well, I have an appointment at 6 that evening, so I would hate to rush proceedings because I have an appointment
You have an appointment at what time?
at 6 PM.
6?
And the council chambers is only available from 4 PM till 5:15 PM on that day.
I
Do you think that's long enough?
I think that would be sufficient, if we're just have this one limited issue.
Yeah, I agree. Okay, so we're talking about which date again? April?
April 4th, or sorry,
10th.
April 10th at
10th.
4 o'clock.
4 PM.
Mr. Chairman, you tell me, but I'm assuming you wouldn't need me there. You could tell me after the meeting if I need to prepare any more subpoenas, but I don't think I would need to be there.
I would agree with that.
I would agree.
Okay.
So that would be 4 to 5:15 or 5:50, Cody?
5:15, there's a
Perfect.
standing committee meeting at 5:15, so if we could, that meeting would have to be wrapped up probably 5 minutes prior at minimum.
Perfect. That works for me then.
Okay,
About 10, 4, what is it, 5:15?
4 to
The
5:15.
meeting would be at 4, let me be clear, it would have to be done by 5:15.
Yes.
Thank you very
And
much.
that would
Yes.
count for this room then? We can use
Yes.
this room? All right. Brian, how's it look?
I put both in my calendar. I can be at both.
Excellent. Doug?
I'm okay.
Okay.
5:15.
So we'll plan on meeting first on April 10th at 4 in this room, and then we have the hearing scheduled for the 30th at 4.
No bad.
All right. Well, thank you.
30th at 4, okay, I better put that down.
Any other comments, questions,
thank you.
concerns from the
Okay.
board members?
Okay. Nope.
Seeing none, I will entertain a motion to adjourn this meeting.
Also move.
Is there a second?
Second.
All in favor signify by raising your hands.
Okay.
Motion carries unanimously. Thank you.
Thank you very much.
No gavel, but
Well, yeah, that was the thing.
Cody was in a bit of a hurry. I think.
Oh, sure. I can't imagine. Because I thought being a bailiff, I would get a nightstick. Apparently I don't. And then I was kicked out of bailiff. Let's go edit. This is ethics board. Okay. Ethics board. Well, that's what you do.